If you're thinking about filing bankruptcy in New Jersey, you've probably heard a lot about somebody called a trustee. And you're probably wondering, who is the bankruptcy trustee and what do they do in my case? The trustee plays a major role in both Chapter 7 and Chapter 13 cases. Understanding their role can help you feel more confident and prepared during your bankruptcy journey. Hi, I'm Perlman. I'm a consumer bankruptcy attorney. I've been helping people get the financial fresh start they deserve for over 30 years. Before we discuss the role of a trustee in your bankruptcy, I want you to know that reaching out to a bankruptcy lawyer does not mean you're filing bankruptcy. It simply means you're trying to understand what your options are. If you find this video helpful, make sure to like, share, and subscribe, and contact our office if you have any questions. The trustee is appointed by something called the United States Trustee Program, which falls under the umbrella of the United States Justice Department. And they play a major role in determining how and in what way your case can move forward successfully towards your discharge. The trustee is a neutral third party. The trustee does not represent you, and he or she does not represent the creditors either. In a Chapter 7 bankruptcy, the trustee is charged with reviewing everything you submit and file with the court. This typically includes the petition that you filed with the court, your schedules, and your list of assets and your debt. The trustee conducts the 341 meeting of creditors, usually by Zoom, asking you questions under oath about what you filed with the court. The most important duty of a Chapter 7 trustee is to look for non-exempt property. Those are assets that may not be protected under the code and can be sold or repaid to creditors. Most Chapter 7 cases in New Jersey are what are considered no-asset cases, where rarely there are assets to distribute to creditors or non-exempt property. In a Chapter 13 bankruptcy, the trustee's role traditionally is broader. That's because in a Chapter 13 bankruptcy, you retain all of your assets. The issue is how much has to be paid back. The Chapter 13 trustee does all of the things that a Chapter 7 trustee does, but is also charged with administering the Chapter 13 plan that you filed with the court. This means that the Chapter 13 trustee is carefully reviewing the Chapter 13 repayment plan that you filed with the court. They are making certain that it provides for each creditor to be paid in the way they're entitled to based on your liquidation analysis. And they do this for a 3 to 5 year period of time, depending on the payment term that you select. And they're also making sure that it's feasible. If you fall behind on Chapter 13 payments, sometimes the trustee will contact you. If you fall significantly behind, they can file a motion to dismiss your case. But the good news is there's due process, and these motions can be defended and default payments can be arranged. The trustee gets paid a percentage of your trustee payment, so there's an incentive for them to make sure that your case succeeds. My name is Perlman. I'm a consumer bankruptcy attorney. If you're thinking about filing, please contact our office so you can understand what your rights are. Remember, reaching out to a bankruptcy lawyer doesn't necessarily mean you're filing bankruptcy. It simply means you're trying to understand what your options are.